Assalamu alaikum and welcome to Perspective. We'll be talking about Election Amendment Bill 2023 and the amendments that are now going to become law. Of course, one of them being the amendment to Article 62(1)(f, whereby a lifetime ban will no longer apply. We'll be talking about the ramifications of this, the fact that of course it will now, according to lawyers and popular legal opinion, extend retrospectively also. We'll also be talking about overall as far as these disqualifications are concerned, their effect is concerned, and the fact that we are talking about ousting from the political process essentially elected leaders of this country through legal means, and the fact that their ramifications then overall of course are on the political process. Of course, the former Prime Minister Nawaz Sharif Saab, and the fact that the way the 62(1)(f, Article 62(1)(f was used, and the way that it was used to disqualify him for life. The fact that now this seems to be the Parliament taking its power in contravening these kind of provisions that have for a time been criticized at least as being bad law. We'll be talking about all of that today. A little later on, we'll also be talking about India becoming increasingly dangerous and unsafe for minorities, particularly now extending to women. The fact that now in assaults for women are now increasing to about 100 a day. But first, of course, the amendments to the Election Bill 2023. I have with me Barrister Yaser Latif Hamdani. Thank you so much for joining us today. We also have with us Rana Maqbool Ahmad, who's a senator with PML-N. Thank you for being with us. Yaser, like I was earlier saying, this is a provision that's welcome in a lot of ways, because for the criticism that this has received overall. The fact that lifetime ban itself is a contradiction in terms. It's something that is permeated the political process, and would you agree sort of halted it over, again, like I said, if we discuss the provision itself, there is opinion that itself is flawed. Of course, the Parliament hasn't scraped it entirely, so it is law at this time. How do you overall look at it?
Well, in terms of the provision itself, when we talk about the provision, it is flawed. It was brought through, a martial law. Essentially, the amendments were made. The 8th Amendment brought it in, and that was under General Zia. However, I think what we've done here at this time in this particular case is we've taken out the sting from it in only in the sense that because previously essentially what we'd done was we actually disqualified a Prime Minister who'd been elected thrice for life, and that was a cruel and unusual punishment in my opinion. And I think that this is what the corrective, and by the way, it has retrospective effect. I saw that there was some debate over that, whether this doesn't have, whether it has retrospective effect, or there wasn't. You didn't need to put it there in the provision itself. This is section 4 subsection 2 of the amendment bill. It talks about a declaration of a court, and that declaration of court, it doesn't say all declarations of court from now onwards. It just says a declaration of court, therefore it applies. So I think, yes.
So you're saying for it to not have the retrospective effect, it had to have expressly said so?
Expressly said so that essentially
it
would apply from now on. So that was not the case, and I think so. In terms of, if you were going to look at it, obviously I think one of the problems in Pakistan essentially throughout has been that you have this unelected so you have unelected institutions in general, and who I mean, there are several which have this inordinate power over the state executive. Now at least we have an opportunity to say that politicians, yes, they can make mistakes, yes, there can be problems, but you can't disqualify a person forever. So that I think is a very important corrective, and that corrective has been made through this amendment. So one hopes, obviously I mean, let's be very clear about it. It's they've done it for Mr. Nawaz Sharif and Mr. Jahangir Tareen, and I think that would be a welcome step for all democratic forces, because the way Mr. Nawaz Sharif was thrown out and the way he was disqualified was, I think now there is hardly anyone who disagrees that was all engineered. Therefore, I feel now that with this provision, this is a we're
undoing a bad law, you think?
Yes, much needed corrective. And yes, we are undoing would be if we took out the provisions altogether, because those provisions 62 and 63, those were, if we could go back to 1973, if we could turn back the wheel all the way back to 1973, then we would have that pristine constitution.
But I want to go back and talk about how things were before this provision was introduced. Wasn't there already laws existing to deal with the issues that have now been put under the umbrella of 62(1)(f), this huge umbrella under which anything can come in? I want to talk about that, but I'm going to go to Rana Maqbool Saab also. Ji, Rana Saab, can you hear me?
Yes, loud and clear.
Rana Saab, this is a provision that, like Yaser said, there is criticism on it. Why do you think that, when clearly there is, at least 80% would agree that this lifetime ban is essentially draconian, and this is being made, if this amendment scrapes it, which is what we've seen, it's undoing, like I said, perhaps the effect of a certain effect of a bad law. Then why the criticism?
My Islam friend, he was talking to his friends about it. It's resounding. My voice is coming back. Kindly check it.
I can hear you loud and clear.
Yes, but I hear my voice back too. Yes. That should be corrected. Very kind of you. This is by all means very unfortunate. It's perhaps the gravest piece of miscarriage of justice, unfortunately. And the honorable judges who decided on that, they were not without bias. I'm very sorry to say that. Can you beat it that under 184(3) they try a person, and a prime minister who tried prime minister, he was running the country in a successful manner. The GDP growth and the systems of working, terrorism was clinched, and there were not many issues which were addressed, and it was a period of spectacular development. So it was a conspiracy against the system and against the prime minister and against the country. It's not only a piece of judgment by honorable judges who threw the justice away and tried to grind their own axe. I don't know why, what was the attraction and fascination for them. So we have made a mockery of justice, unfortunately. Look, there's no appeal, unfortunately, nor that creating hue and cry, and that the parliament has provided for appeal. Is there any law in the face of this world that there is no appeal against any order of punishment? Don't you violate the fundamental rights? If at all you try to interpret Constitution, you should interpret in a judicious manner. You should have pointed out a right of appeal has to be there. In the new legislation, which of late which was passed by the Parliament, right of appeal has been guaranteed. So this and this, the other issue they say it is retrospective. What do you mean by retrospective? Should you slaughter people right, left, and center, and then leave the issue on technicalities? You have to ensure justice. This is the duty of the Supreme Court. Foremost obligation on the Supreme Court to revisit their judgments. No judgment is a final judgment in that spirit. Once there is a judgment full of flaw under the articles of Constitution, perhaps it's 187, because the Supreme Court is a court of complete justice. They must review their own judgments. They should revisit their own judgments. They haven't done it. So this is all hue and cry. It doesn't have any substance. They're all propaganda is repugnant to the spirit of justice. This is a judicious bill. I am party to it. I was sitting there and we argued it. And there is nothing against law and against the tenet of justice. If at all we talk against this is against the tenet of justice. No,
Why not do away? I mean, this is a question that I think is in the minds of a lot of people who see it, see the provision itself as problematic. And can you hear me, Rana sir?
Yes, Chaudhry.
As the provision is problematic, and of course, had the Parliament chosen to do so, they could have done away with it altogether. Why not do that?
No provision this provision will not be able to be implemented, the previous one, because I heard a jurist like Khalid Anwar saying these provisions have been drafted by kids, 62(1)(f) and 63, because these are against the tenets and against the principles of justice. How can you disqualify a man? And look at the inadequacy in the provision. 62(1)(f) does not specify any punishment. It specified the punitive action against the guilty persons, but it does not specify any provisions for punishment and for the time and the duration. So it all depends upon the discretion of honorable judges, and they have misused their discretion in a very indiscreet manner.
Let me come back to you. Rana Sahab, on that note, let me come back to you. Yaser, do you agree? You think this is largely precedent based? The lifetime ban.
The lifetime ban is essentially it emanates from a judgment.
Okay.
And I think that's what the corrective here is. You've now introduced something into the Election Act through the Election Amendment Bill.
By precedent.
But now you're overruling the precedent.
Through this amendment.
Yes, and that is something the Parliament can do and should do, because and has been done in other places. So I feel that they've I would imagine leaving it to precedent would have been, and has led to disaster, as you can imagine. I mean, this is what's been happening in this country for a while now, where we've had judge-made law. And not in the sense that judge made law through precedent, but we've had rewriting of the Constitution happening, and we've seen that with 63A as well. So I think that with this particular amendment and putting 5 years, but I would go back to what you were saying, and I think that's the more important part. In 2010, the People's Party government tried to take these provisions out of the Constitution through the 18th Amendment. The most resistance that came up was from the PML-N.
Okay.
That was, that's and that is something that they would have to now consider.
Perhaps taking them out altogether.
Or taking them out altogether, and all the parties have to come to this.
Because like consensus. I was earlier saying, that if you talk about, any kind of, let's talk about offence that falls under 62(1)(f). What are some of the major offences which have sort of, clubbed as far as Jahangir Khan Tareen is concerned?
Well, any place, anywhere a person is not Sadiq or Amin is
because of whether it's assets beyond means, or whether it's fake degrees, or whether it's
insider trading,
or making a statement on your misstatement on your declaration on your election papers, as I understand.
Yes, and that's something that would obviously be
actionable anyway, right? So it would be actionable under other laws already. So why would you need a blanket law to sort of club all of those, and then make 62(1)(f), which would disqualify you under Sadiq and Amin, and therefore ban you for life. So essentially it means taking out people who are part of the political, your elected representatives, part of the political process. And if you are talking about a democracy, under a democratic system, it is the people who should have the right to do that, right?
Always. It has to be the people who decide who governs them. And you can't have this, whoever sitting in judgment on whether a person is a fit candidate or not. That is something that should be taken out of the purview of the judiciary even. I would say there shouldn't be qualifications for elections. Let the people decide.
Look at Rana Sahab, look at Nawaz Sharif Sahab, look at his own party. The fact that he has been disqualified under this provision has not taken away from the fact that he is the PML-N. Would you agree that today your vote bank, as far as the PML-N is concerned, yes, you have other leaders, yes, there's no denying that there is, the Prime Minister, of course, as the President, or Mariam Nawaz, all of them have their appeal, but your PML-N is Mia Muhammad Nawaz Sharif. Isn't that true? The fact that you have disqualified him has had no significance, except, of course, that he has not been able to contest elections. But other than that, you have not been able to erode his appeal, or you have not been able to take him out of his persona as the leader of one of the largest political parties at this time. Isn't that true?
Absolutely correct. Your appreciation is commendable, and his qualification is his dedication and sincerity of purpose to the nation. He has given this nation a lot, like defense impregnability. I don't think so that can be defined. The utility of that initiative which he took and made Pakistan an equal power. Your defense is impregnable and invincible. Otherwise, India would have ripped into pieces, in this country into pieces. India is such a virulent enemy, they would have done everything with Pakistan. Nor they can't resort to naked attack against Pakistan. That is the situation which Mia Nawaz created with his endeavors to protect the nation, and lot many other works.
So you can't take political leaders who have mass appeal out by mere technicalities, right?
No, it was not a technicality. It was a big assault on the integrity of the system. There was a nexus of evil. One or two generals, one or two judges, they join hands and they destroy the country. This is what they have been doing since the misadventure of Justice Munir. What are they have been doing? They have not been serving the country. It is very unfortunate talking against judges like this. But they have done this. They have destroyed the country altogether. East Pakistan wouldn't have been separated, and there would have not been too much of casualties which happened had Munir not laid the foundation of systematic politics. So this is all very supporting the crime. They have been doing it. And they also did in 2017. So this is not a hidden, everybody knows that. No, at least they have to be stopped at some juncture. Or they have been stopped at this juncture. God willing, this law will get stabilized. And my friend has pointed out, correct. In our meetings, we always criticize. Why didn't the PML-N put an amendment in the Constitution? Because 18th Amendment, it brought a host of constitutional amendment. Why did they overlook this 62(1)(f)? This is not proper. The impropriety of the action of the Muslim League is to be explained. There are no reasons, so they suffered. But rightly, people were saying, even then, let's amend, it was just it was not a constitutional amendment, let's amend the NAB laws. Our people didn't do, and they paid through nose. Everybody paid through nose. And once they suffered, then they realized these should be amended. So these erratic assessments on my party, we must own it, and we must not repeat it. We don't hide this fact. It was our negative contribution, which is not permissible by all means. Mia Nawaz Sharif I'm so happy to listen to you. What a correct and pragmatic and objective appreciation. And you will see once he inshallah comes, we'll be again on the track.
Let me come back to you. Yaser, let's talk about the concept of contempt of court, for example, which stands you disqualified for 5 years.
Well, any conviction would.
Any conviction would. And contempt of court is one of those convictions.
And contempt of court is, yes.
And contempt of court is also a huge is this also, what constitutes contempt of court, for example?
Well, historically or by precedent, we saw what happened with Prime Minister Yusuf Raza Gilani. He was convicted of, or was said he was held in contempt because he had refused to write a letter to the Swiss authorities, and that was the order of the Supreme Court. So by not following through, he was held in contempt.
But saying something that would be, what would be the right word, against any of their lordships or the court in general could also constitute contempt of court.
Well, that would be a very narrow way of looking at contempt. I would imagine, I mean, fair criticism, the Constitution allows fair criticism of, judgments. Now, if somebody was to start, abusing the lordships, then that might constitute some sort of contempt. But just mere criticism of the judges or their decisions is not contempt. It can't be contempt, and it should not be. It can't be in a democracy. If that was to happen, you would essentially basically make the judiciary completely, you would put it far above everything else, and in terms of, I mean, then that would be the answer to your question of who's supreme. If the judiciary had this power, then judiciary would be supreme. But however, there isn't any such power at the moment.
But at this time, we have seen, unfortunately, a kind of battle, so to speak, as far as for supremacy, as far as your court is concerned and your parliament is concerned. Of course, essentially, by definition, the functions of both are very different, and of course there is that whole concept of separation of powers. But as a lawyer, seeing what's happened in the very recent past, how do you look at the concept as in the light of our recent history, and the fact that we've also now having a parliament that is reasserting its own supremacy to legislate?
Well, I think it's a positive that our parliament is now, and essentially, if you look at the Pakistani constitution, you look at sort of the framework. Pakistan is a federal parliamentary democracy with independence of judiciary. This is the basic structure of the Pakistani constitution. It's a federal parliamentary democracy. Now, a parliamentary democracy has a specific connotation, and in that, the parliament is supreme. Now, I've heard a lot of, and a very popular counter view to that is that the parliament is not supreme because the constitution is supreme. But that I think is a misreading of the entire, when we talk about the parliament, the fact of the matter is the constitution can be amended by the parliament under 239 by a 2/3 majority, and therefore the parliament can amend the constitution, therefore parliament is supreme. Parliament can, and it is the parliament that fixes the number of judges. The reason why there are 17 judges at the moment in the Supreme Court is through an act of parliament in 1997.
But you have a supreme judicial body anyway, right? That holds the judges themselves accountable, and that's another system entirely.
That's a question of accountability. But when we come to the question of, I mean, I know that it's not a very popular view that I mean, people like to say that parliament and judiciary and the executive are co-equal, but that is not the case. In a parliamentary democracy, it is the parliament that is supreme.
But essentially, of course, the functions are different. I mean, your judiciary has to essentially, interpret the constitution, and your parliament can legislate. As far as whether we're speaking, generally speaking, they could legislate anything.
They could, yes, and they could. And for all practical purposes, so long as it doesn't violate the basic structure of the constitution, the parliament can go on making as many amendments as it wants. Therefore, and other than, so what the parliament can do is abolish judiciary. It can't say Supreme Court will no longer exist. That's something that the parliament can't do.
Because that would be against the constitution.
Exactly, and that would be against the basic structure of the constitution, which talks about independence of judiciary, not just in, it also talks about, not just in 175 and so on, but it also talks about the independence of judiciary in the Grand Norm, which is the objectives resolution under Article 2A. It also talks about the independence of judiciary. So as long as the parliament legislates within those limits, and those limits are the basic structure, the parliament can change the constitution. The parliament can tomorrow decide that instead of having 17 judges in the Supreme Court, we'll have 29. And that is called, and pack the Supreme Court with its judges, and that's happened elsewhere as well. In terms of, I mean, even if when you look at it, places like the United States, which is not a parliamentary democracy, it's a presidential system, but has the principle of separation of powers. Even there, it is the Congress that controls, that has a regulatory control over the Supreme Court of the United States of America. And that even in that system, which, you know, because United States famously calls itself, or historically has called itself, the Republic of Laws. Well, even in the Republic of Laws, where judiciary has such a central place, the fact is that the Congress regulates the judiciary. So in Pakistan as well. Yeah.
Rana Sahab, there's another amendment that's been made as far as, you know, that is to do with the Election Commission. It is empowering the Election Commission now, and not in consultation with the President, where it was before, you know, to hold the elections, to give the date of elections. As far as this provision is concerned, of course, you know, we've seen recently what's happened as far on the date of elections. Empowering the Election Commission in this way was needed because of this recent past. This change was needed because, you know, we saw the consultative process, of course, was not binding, but it took some time.
Yes, this is a justifiable action which has been taken, because the presidential role, at least now, was not a fair role, and it was not between the lines, and therefore Election Commission was hampered from performing its duties. And this interpretation of 63A, etc., it rather ridiculed the law and the spirit of propriety, unfortunately. Therefore, it had to happen, and it's a action in the right direction. I may submit in 2 sentences about the supremacy issue, as my friend also mentioned. Supremacy is not a controversial issue. Supremacy has to be of justice, propriety, honesty, competence. If the honorable judges, they act in a real, impartial manner, they'll be the most favored people in the country. I have been always praying and requesting the honorable judges, let's not try to follow Munir Ahmad and Anwarul Haq and Rashad Hassan Khan and Saqib Nisar, etc. We should try to follow Cornelius and Hamood Rahman, Ajmal Mia, Nasrul Mulk, even Rana Bhagwan Das. You have models with you, but you try to follow the models which have mutilated the legal position. They have not been working, these people. For example, my friend mentioned both Sadiq and Hameed. Sadiq is not mentioned in the original law, 62(1)(f). It's Amin. So there was some judgment in which Sadiq and Amin, and look, the awards of Sadiq and Amin were distributed by such honorable judges who have created a lot of doubt for themselves due to their conduct. So basic is purity of intention and action, which makes the person or the institution supreme. If the parliament try to do something which is against the spirit of justice, and especially as my friend has mentioned, about the basic spirit is the Islamic injunction, like in the objectives resolution. That is the regulating spirit of our constitution. Anybody or any institution, if violates, that is mean he or she or the institution is deviating from the path of virtue and justice. So basically, the path of virtue and justice is supreme. That should be the objective of all institutions and of all individuals who are sitting on such high echelons of power and authority, like Supreme Court as well as Parliament. So all of us will have to have full determination and consensus to do a right thing instead of going for chauvinistic or personal interest or
Mahrukh,
institutional
do you think
interest
there's a
or
chance?
individual interest.
Do you think there's a chance that the Parliament may, at a later stage, of course, we're very close to the elections, whatever shape the Parliament may take after the elections, do you think there's a chance, you're a lawyer also, and your opinion as a parliamentarian, that they would maybe scrape away the article altogether?
Oh yes, that there is a overriding and a very powerful feeling in the senators as well as the parliamentarians. They must do away all the laws which were, especially as my friend has mentioned, 8th Amendment. This is to be re-examined, all provisions. There are provisions, there are laws which are against the rights of the people. May I mention, if you induct people into services straight away and you put them senior to the people, since they are from the regimental forces, and you deny the right to a poor man's son or daughter who struggle all along for 25 years to get into services. And you give these things to those people, the rights to those people who don't deserve it, who don't have any right. It means the government itself.
And the struggle of your political, legislators, like yourself, your, political leaders also, is largely ignored. The process, their lifetime struggle of, whether if we look at the former Prime Minister Nawaz Sharif Sahab, or we look at, any number of leaders, is, by this one article and this lifetime ban which was earlier in place. So the unfairness of it, right, is right in front of us, and the fact that it's draconian in a lot of ways. Let me go to Yaser on this. Yaser, do you think that as far as this provision is concerned, with regard to the Election Commission, do you think it's given a lot of clarity to the issue? Because of course now it's quite clear that it was only the Election Commission that is empowered to give a date as far as the elections are concerned.
I think that was one of the questions that came up with the provincial elections that were when the provincial assemblies were dissolved. This was one of the. So I think this was a very important amendment because I think the Election Commission is the right body to decide, and ultimately we have to come to a point, and this is something, obviously it's on the wish list of all Democrats, as it were, in Pakistan. Ultimately, we need an Election Commission to be powerful enough to make all these decisions on their own. Okay. Without getting the leader of the opposition and the Prime Minister together and deciding on a caretaker government. Because you see, if the whole caretaker issue was out of the picture, if you had an independent election commission that was empowered enough to actually carry out elections without political interference, then you wouldn't need caretakers. Then incumbents could hold elections. Then the government would complete its tenure and then hold elections at the very end of its term. So I think that is why this is very important. I think empowering the Election Commission would be very important in terms of getting Pakistan on that track to becoming a mature democracy, which unfortunately it isn't at the moment.
Right. I have to move on and talk about the other segment. Thank you so much for being with us. Yaser, thank you for joining us, and Rana, Maqbool Saab, thank you for your time. We'll be taking a short break, after which we'll come back and talk about minorities and their difficulties, particularly women, increasing as far as India is concerned. Welcome back. We have with us Nida Salam Chaudhry, who's a human rights expert, also an activist. He's also an Indian affairs expert. Thank you for being with us. Nida, can you hear me?
Yes, I can hear you. Can you hear me?
Ji. Nida, overall, of course, we've seen what's happening recently as far as the state of minorities is concerned in India. We've also seen recently the status of minorities and the fact that, you know, they're being discriminated against. It started with Muslims, it started against Kashmir, particularly we saw the treatment being meted out to the Muslims there. And now, of course, we've seen a startling increase as far as women is concerned. How do you look at what's happened, and what do you attribute this horrific increase in assaults for women also, of women?
All right. Thank you very much, Mahrukh, for the invitation. It is my pleasure to be in the discussion. First of all, I would like to utterly condemn any sort of violence, and especially the emerging rape culture at the moment in India. For instance, in contemporary societies or years, rape is the fourth mass plebeian and prevailing crime against women, and it is used to vindicate the powerless in society. Ginormous number of rape cases are not reported because of the culture, society, taboos, humiliation, and hostility. Unfortunately, the current statistics by the National Crime Agency and Human Rights Watch are very disturbing. According to them, in 2022, almost 428,278 cases involved crime against women were reported in India, and it's a rise of 26.35%, and from 338,954 to 4 lakh almost. Majority cases are in relation to abduction, dowry deaths, rapes, domestic violence and assault. 107 incidents were reported as acid attacks, and 2,668 women were the victim of the cyber crime. So India has earned the moniker, which means the rape capital of the world at the moment, or violence capital of the world for women. World's largest democracy, and Modi's India gets a bad name because the way victims and survivors are unfairly treated. Victims are stigmatized and shamed by the society, by the police and judiciary too. So the story of the unfair treatment of Bilkis Bano, which the world has experienced, how can we forget the story of Animika case, Nabiha rape case, and very famously Jyoti Singh rape case, which terrified the world across the which terrified the women across the world. And Jyoti rape case was also called as the worst bus rape case referred as. So according to the recent research, I strongly believe that the majority rape cases were, or the rapists were convicted by the lower courts of India, but upon the appeals in the High Court or the Supreme Court, they were acquitted. So I strongly believe that Indian legal system miserably failed to protect the women and failed to provide justice to Indian women. So another report, according to the recent World Bank report, dowry was paid in 95% of marriages. The brides who failed to bring the sufficient dowry are murdered, harassed, and marital raped. So violence
according
against
to a
women
survey
is horrific.
recently, we've also, you know, seen that there's a particular lack of interest from the agencies as far as crime against women is concerned. To what do you attribute this? Is it, you know, as far as lack of education overall? You know, is it lack of awareness? To what do you attribute this attitude overall, which has now been documented according to reports in India?
Mahrukh, I will not agree with that point of lack of education, because India considered herself world's largest democracy and, you know, economically game changer in the region and blah, blah, blah. So when it comes to education and awareness, I don't think so that that is a problem. The problem is that the institutions, for instance, the courts or the legal system, or you can say the laws, are not into practice. For instance, long sentences, you know, chemical carcination and all that. So again, a lot of human rights activists have recently researched that in India they are spreading awareness, and yeah, that I can say that in today's 21st century, I don't think so that we can say that people are not aware what it is and how it's happening. I would like to quote here something. Andrea Dawkins once stated that by the time we are women, we fear by the time we are women, fear is as familiar as air to us. It is our element. We inhale it, we exhale it, and we live within it. And sometimes we don't even notice it. So I will agree with her that because India is considered as the hub of the rape culture. And another very important thing I would like to add here, the country crime statistics recently explicit that a woman is raped in India in every 13 minutes. It means that the Indian government somehow under the umbrella of Modi, recent Prime Minister, are not taking effective steps to protect their women. The current Prime Minister of India and his cabinet failed to protect the constitutional rights of the Indian women, right not to be tortured, right to have fair trial to prevail. The most painful and lingering case I would like to add here, the Mumbai nurse case, Aruna Shabang. According to many human rights reports, even United Nations reports, even Indian military in Indian occupied or Indian administered Kashmir use rape as a weapon to silence and suppress women. So when all these things are happening with the consent of the government and their and a member of the institutions are conducting the same heinous crimes, so on other hand, how they will protect the women's right within the home actually?
Nida, is it that you think that because it started with the Kashmiri women, it started with Muslim women, and then overall it has over time permeated into society as a general now, because that attitude of it becoming I don't want to say it, but it becoming part of the course, something that's happening. It's not, the sensitivity, the lack of sensitivity is now rampant in that society.
I agree with you, Mahrukh, on that perspective. You know what? Violence against women is deeply entrenched in feudal and patriarchal Indian society. I would like to quote here. In 2003, the country was shamed when 28-year-old Swiss diplomat was raped in her car by two men. So imagine in Delhi, a foreign diplomat serving in the country was raped. So how you can expect the government to protect a normal, poor woman of the society and all that? So as far as you gave the reference of Indian administered Kashmir and all that, I will agree with you, because when the Indian government in the past and the current allowed the members of the institution to conduct these heinous crimes, it means that like for them it's not a big deal, and even Indian government is not ready to consider the rape as a big deal, or to protect women, because most of the cases which I have recently researched, that they are acquitted by the High Court and Supreme Court, and I couldn't find any voice from the arrogant cabinet of the Modi in any rape case in terms to raise voice for the women, or to talk about their rights, or to protect their rights. So yeah.
So when we say that India as a secular democracy, if you look at their overall their entertainment, their arts, overall, the kind of, again, the kind of culture that is being depicted internationally, it's a facade, and it's unnatural, to what is actually happening at this time in India. Do you think that now it is becoming increasingly exposed that it's an unsafe place for not only minorities but also, like I said, women?
India is considered as the world's most dangerous place for the women to live, according to the international reports, according to Telegraph, Guardian, and New York Times and all that. Besides that, a lot of valid reports by United Nations and UNICEF and all that organizations, where they call that the rape culture is emerging in India. So the film, the culture, the depiction you gave a reference, Mahrukh, that is just till the television, I believe so. But when it comes to reality, I would like to give you example of women from Dalit community. The way they are suffering in today's time and age is horrendous, where like women are progressing in their professional lives and traveling across the globe. On the other hand, women from Dalit community are suppressed and discriminated on daily basis, from employment to living, from traveling and all that. So again, I strongly believe that the states where the governments are not ready to take the steps, and they fail to protect the concerns of their citizens, no matter they do call themselves largest democracy, but somehow on ground reality is very different.
Right, fair enough. Thank you so much for joining us on this
Thank
very
you, Mahrukh.
important topic. Thank you for your very valuable input. Overall, of course, we saw, as far as the Article 62(1)(f) is concerned, the lifetime ban as the Parliament has scraped it, and its ramifications generally for the political process at this time for Pakistan. Also, of course, the Election Commission and the fact that the power unilaterally empowers the Election Commission now to give a date. In addition to this, of course, this will mean perhaps a kind of clarity in this democratic setup for the future that was clearly awaited. It will also mean that elected representatives of the people of Pakistan in a democracy like Pakistan cannot be ousted through the legal process in this manner in which we saw in history earlier on. Thank you so much for joining us today and listening on these very, very important changes. Also, of course, violence in women, minorities overall, the increase in that, and of course the flagrant abuse that we are looking at as far as India is concerned. Thank you so much for joining us today on Perspective.